Hey, if you're a licensed beauty professional in Kentucky, listen up, because there's one regulation you absolutely have to know. It's 201 KR 2190. And you should think of it less like annoying red tape and more like a legal shield that's there to protect your license, your business, and your entire career.
So, picture this. You're in the middle of a busy day, and an inspector walks right through your door. They start pointing things out, telling you what to do, maybe even threatening you with a fine. Your heart starts pounding, right? In that moment, do you actually know your rights? Do you know what they can and can't do? Well, by the end of this, you're gonna.
All right, let's break down that exact scenario. Because when that knock comes, knowledge is going to be your most powerful tool.
First things first, who does this law even apply to? The answer is simple: everyone. It doesn't matter if you own a salon, run a beauty school, or you're an independent professional with a license. This regulation covers the entire disciplinary process for every single person with a license in Kentucky. Nobody is exempt.
And this, right here, gets to the absolute heart of a huge and potentially very expensive misconception. If an inspector gives you a verbal warning or starts making demands without any official paperwork to back it up, that is not lawful enforcement. The whole system is literally designed to prevent that kind of informal, undocumented pressure. Okay, so if verbal demands are off the table, then what is the right way? Well, that brings us to the core legal principle that protects you: the power of due process.
Due process sounds like some complicated legal term, but it's actually pretty simple. All it means is that there's a fair, established procedure that the state has to follow. It guarantees you the right to be properly notified about any alleged violation, and it gives you a formal chance to respond. It's all about fairness and transparency.
I really love this quote because it just nails it. Due process is not an obstacle. It is the foundation of lawful regulation. See, it's not some sneaky loophole for you to get out of trouble. It's the very thing that makes the system fair for everybody involved. It protects you, and it actually protects the integrity of the board, too.
So let's be absolutely crystal clear here. These rules, they are not optional. They're not suggestions or best practices. This is what's called black-letter administrative law, which is just a fancy way of saying it is written in stone, it is legally binding, and the board must follow it. Period.
So, how does all this work in the real world? An inspector is actually standing in your salon. In practice, due process creates a mandatory paper trail for everything.
The law couldn't be clearer. Everything has to be in writing. Any disciplinary action has to start with a written complaint. From there, you have to get a written notice of the violation, a written citation of the exact law you supposedly broke, a written notice of your right to a hearing, and finally, a written disclosure of any penalty they're proposing. Bottom line, if it isn't in writing, it's not legit.
And what exactly qualifies as a complaint under the law? It's not just a rumor or an anonymous phone call. The regulation is very specific. It has to be a signed piece of writing. In fact, the law goes out of its way to say that anonymous complaints will not be accepted. That holds everyone accountable right from the very first step.
Look, the difference here is really night and day. On one side, you have the lawful process. It's all written, it's formal, it's documented. On the other side, you have these unlawful shortcuts: verbal warnings, informal demands, fines being thrown around without any proper procedure. Knowing which is your absolute first line of defense. The moment you receive a formal written complaint, a clock starts ticking. The law guarantees you 30 calendar days to prepare and submit your own written response. This is such a critical part of your rights. It's your official chance to tell your side of the story, to clarify things, or to correct the record, all in writing.
Now, you might hear people talk about settling things with an agreed order, but it's so important to understand that this isn't a shortcut to get around the process. An agreed order is a formal resolution that can only happen after all those required written steps have already been completed. The takeaway here is simple: no paper trail, no lawful penalty.
Okay, so you know the law, you know the process. How do you actually put this into practice to protect yourself? This brings us to the final, and I think the most empowering part: your professional rights. So here's your playbook. First, always request written notice for everything. You can be perfectly polite about it, but ask for any issue to be put in writing. Second, always respond in writing. You need to create your own paper trail. And finally, always ask for the specific law or regulation you've allegedly violated, and then just document everything.
Keep copies of every single communication, emails, texts, you name it.
And let me be really clear about this. Respectfully asking for the official process to be followed isn't you being difficult or resistant. It's you demonstrating professional literacy. It shows that you respect the law, you understand your obligations, and you also understand the protections that you're entitled to. It's the mark of a competent, serious professional.
And really, that brings us to the final question you have to ask yourself. Knowing all of this changes things. Are you just an artist who's practicing a craft? Or are you a regulated professional who's building a sustainable career? A true professional knows the rules, documents everything, and operates with the confidence that comes from understanding the law. Go out there and protect your livelihood by being that professional.